So we jump forward 8 years to Stenberg v. Carhart, and this is another sharply decided 5-4 decision. And the issue in this case was were partial birth abortions. And the partial birth abortion in this case in Nebraska, partial birth abortion was criminalized. So in this particular case, in the state of Nebraska, it was a felony to engage in partial birth abortion, except with the sole purpose of saving a woman's life. On top of that, in addition to the felony, the doctor who performed the abortion would automatically lose his license to practice medicine within the state. The law, however, was pretty specific in defining exactly what a partial birth abortion was. Because of that, the law in question and the Supreme Court opinion are fairly graphic in terms of the detail in which they describe this procedure. There were and are two types of procedures that can be considered partial birth abortions. One's called a D&E and another is called a DNX, both of which could be covered by the law, even though only one of them, DNX, was designed to be covered by the ban in this particularized case. But it wasn't at all clear within the law. A doctor could only think that DNXs were banned and then perform a D&E abortion, but then be subjected to the interpretation of the state attorney general that criminal penalties and a loss of your license were appropriate. And it's for all of those reasons that I just articulated that the court, in this case, the majority, the 5-4 majority, argues that the law was unconstitutional because it placed an undue burden on a woman's attempt to obtain an abortion for a non-viable fetus. So they use the language that O'Connor has articulated numerous times since 1983. They use the language of unduly burdensome. Now, this is a 5-4 decision, and Justice Breyer, who was a Clinton employee, writes the decision. So the Supreme Court states that both under Roe and Casey, once a fetus is viable, the state has an interest in both the life and health of the mother and the fetus. Yet, based on this law, only the life of the woman was protected, but not her health. And so, because of that reason, they deem that this law, because it places an undue burden on a woman's right to choose, is therefore unconstitutional. As one can imagine, the judges in dissent are not at all pleased. Justice Kennedy dissents, stating that Casey made very clear that the state has strong interests in promoting the potential life of a fetus, which was balanced against a woman's interest in obtaining an abortion of a non-viable fetus. But the majority's decision in Stenberg, he argues, goes against how he understands Casey. He says that the court's decision today, in my submission, repudiates this understanding by invalidating a statute, advancing critical state interests, even though the law denies no woman the right to choose an abortion and places no undue burden on that right. The legislation is well within the state's competence to enact. Justice Thomas also dissents, although his dissent speaks more to the core of the nature of Roe v. Wade as well. He dissents basically saying that Roe v. Wade was grievously wrong, and although a state may permit women access to abortion, the Constitution absolutely does not dictate that a state must do so. So Thomas would overturn Roe v. Wade. Justice Rehnquist and Justice Scalia also dissent in this case, making a very similar argument. So again, here we are, and the Roe decision survives again. And that's somewhat impressive. Congress, however, after the year 2000, passes its own law. And it passes the Partial Birth Abortion Ban Act of 2003, which was signed into law by President Bush. Understand that President Clinton vetoed this law when he was president. The law in question, based on the decision in Stenberg, would seem to be unconstitutional because it only allows the abortion to protect the woman's life and not have a health exception. Yet the court seems to weigh in differently in the next case that we're going to hear, which is Gonzalez v. Carhart.